Hi, good evening, everyone. This is Kenya Rockman, author and founder of the Child Support Hustle. Comment moderation. Let me see. Okay, I'm not going to set the comment thing. Okay. Hope everybody's doing well. I was going to, let me see. You know, every time I go live, I have to wait and see. Yeah, I hate it too, Mike. Okay, wait and see if everything is hooked up because things change so fast and I don't know. I'm not that advanced. So anyway, how's everybody doing out there in social media world? I hope everybody's doing well. I'm doing okay. Thank you for anybody that cares or asks. Again, I'm Kenya Rockman, author and founder of the Child Support Hustle. I'm going to get this light out of my eye because it is blinding me. Okay, so I don't know if anybody saw today, I made a post about a Kentucky judge that has been reprimanded for putting a father in jail for contempt of court. It was not for contempt of court on the child support charge that he was in there for, but because of other reasons that I'm going to get into, and reasons that, of course, I have a problem with. Anybody that's new here or everybody else knows that debtor prisons, I'm trying to get a bill passed to re-abolish debtor prisons, especially when they're using child support cases. For obvious reasons, they were outlawed in 1833. So the Kentucky judge, he had a hearing for this father, and I'm going to get this over here. Okay. Let me get situated here. Okay, so this is according to an article on Kentucky.com. The judge's name is Robert B. Conley of Greenup, Kentucky. If I mispronounced that, my fault. So he told a man to shut up after listening to him explain why he hadn't made child support payments. He then questioned the man about who was responsible for making the payments, but when the man tried to answer, can y'all see me okay? I don't know. It's like funny on here. Let me know, please, somebody. Let me know if y'all getting me okay. Maybe if I come back. Yeah, that's a little bit better. Okay, so let me start over. So the judge told the man to shut up after listening to him explain why he hadn't made child support payments. He then questioned the man about who was responsible for making the payments, but when the man tried to answer, the judge banged his gavel. Thanks, Marquise. Hey, how you doing? Banged his gavel and told the bailiff to send the man to jail. Okay? So many problems with this. First off, this man was facing time in prison anyway. He was facing imprisonment because in Kentucky, even if it was a Class A misdemeanor for failure to pay child support, it's up to 1 year in prison and a $500 fine. Or in this case, he was in there for flagrant non-support, which is a Class D felony, which carries 1 to 5 years imprisonment and a fine between $1,000 and $10,000. So my question is, why didn't this father have a lawyer? There's been an argument going on forever that if you're going to jail or going in front of the judge for contempt of court for child support, that you don't need a lawyer. They don't have to appoint you a lawyer, right? But in Turner versus Rogers, which was decided back in 2011 by the United States Supreme Court, the American Bar Association noted that their standards of criminal justice support a right to counsel with incarceration is a possibility. And I put everything that I'm talking about, I put in the description of this, so you can go and click the links. If you want to use it as a reference, if you want to go check this stuff out. So they said this back in 2011. And in that brief that they described, this is the American Bar Association, the brief said, and this is a quote, "The line between civil and criminal contempt proceedings has become increasingly blurred," okay, "and thus cannot provide a useful basis for determining the right to counsel where personal liberty is at stake." End quote. It was blurred before it started, when they started locking people up for child support when they couldn't afford to pay. It was already blurred. So in 2011, after the Supreme Court decided this about criminal contempt and locking people up, and then the American Bar Association came out and said it was blurred, they continue to do it. So this, my point is that before that man, he should have had a lawyer talking for him, since he was facing at least a year and up to 5 years. So his personal liberty was at stake. So let's go on. Now, this is just a thing. When I'm reading the article, they know that this is a father. They know, the people that the author of this article knows that this is a father, but they keep referring to him as the man, as if this is a criminal that doesn't have rights. So everywhere in the article, instead of saying father, they're saying man, man, man. So I just think that that's something that the media does to separate the father, or make it seem like a father doesn't have rights when he goes to court. Now, they know he's in there for a contempt of court with child support, but they continue to not use the term father, but only describe him as a man, to kind of lessen what he's doing there, because they don't want to address the reason that he's there, which is failure to pay child support. But I'll get to that in a minute. And I also want to point out that for Kentuckians, this judge, Robert Conley, is running for the state Supreme Court against State Rep Chris Harris of Forest Hills. Now, we know how Judge Conley treats non-custodial parents when they come up in his court. He bangs his gavel and sends them to jail when they try to explain why they haven't made payments. So you might want to call Judge Conley and Representative Chris Harris and ask them, if you make it to the state Supreme Court, what are your views on child support reform? What's going to happen if you are elected to the Supreme Court? Are you possibly going to pass any reforms, any new legislation to help non-custodial parents, and especially with this debtor prison law? Okay, so let's talk about the reprimand. The Judicial Conduct Commission stated that Conley, 1, failed to conduct a hearing to make a written finding of contempt. This is just in the contempt of court, not child support. And 2, admonished everyone in the courtroom that were speaking over him that he was contemptuous, and that this father was contemptuous and would be treated as contempt of court. So everybody was going to be treated like this. But anyway, the father spent 3 days in jail just on that contempt charge, and nothing was addressed about him being in there for child support, not even or him being in court in the first place for child support or failure to pay child support. Not even when the commission concluded that Conley had violated SCR 4.020 by engaging in misconduct in office, along with violating SCR 4.0, and these are the following violations. Rule 2.2, which requires the judge to perform all duties of judicial office fairly and impartially. I'm going to address that with, or relate that to family court. How many parents, not just in Kentucky, but all over the country, are treated fairly and impartially? I'm sorry, I skipped one. I'll go back to it. When it comes to going in front of a judge in family court, these are the violations. But I'm going to go back. Rule 1.2, which requires judges to act at all times in a manner that promotes public confidence in the independence, integrity, and the impartiality of the judiciary. We know that family courts are biased towards fathers. We know that they do not promote public confidence. They are not independent. They do not hold integrity or impartiality when it comes to deciding in family court what parent should have custody, who should be paying child support on a 50-50 if the parent is already supporting their child without a child support order. We know that they'll look at those as gifts, which they are not supposed to do, and order child support anyway. So I'm comparing this what they have charged him and reprimanded him for. I am comparing this to the child support and family court system and wondering why they didn't address any of this, knowing that this father was in court anyway for failure to pay child support. And the last rule, 2.8, requires that a judge be patient, dignified, and courteous to litigants, jurors, witnesses, lawyers, court staff, court officials, and others with whom the judge deals in an official capacity. We have seen numerous videos now. People have witnessed, myself included. You go into court, especially family court, you try to plead your case, tell the truth, or you're talking about your children, and they shut you up. You don't get to say your piece. You don't get to say anything. They just rule, next case. So as far as them being patient, dignified, and courteous, we know that's BS. So I keep saying that because with this commission, I'm just baffled as to why they didn't address any of these issues when this father was there for a child support case. But I'm gonna get to that too. So the commission stated that they rendered this decision, this reprimand, instead of him being fired. They issued this reprimand based on Conley fully cooperating with the investigation and telling the commission that on the date that this happened, which was January 2nd of this year, he was suffering fatigue from the flu. So he was able to violate this father's rights, and he also sent another man to jail for contempt, not child support related. That's why I'm not discussing him, but I thought I'd bring it up. He was able to violate both of these men's rights and then his father's rights based on him being tired. Yet, fathers and mothers, I'm not forgetting you ladies, go to court with legitimate reasons why they cannot pay child support. And this is a perfect time to mention this because COVID-19 has left the country, so many people unemployed. The government is refusing to cancel child support payments during this difficult time. But he can have the flu or be tired. He doesn't even have the flu. He's still tired from the flu. Violate people's rights and just get a slap on the wrist for sending people to jail, taking their freedom for not one day, and then I'm sure he felt better the day after. I'm sure he got some rest. The second day, I'm sure he took some medicine. The third day, he finally, I guess, felt better, so he just got a slap on the wrist. Okay, so I'm saying we know the arrest was based on the regular contempt, but with the father appearing in court, and he's trying to explain why he can't pay. We got to figure out or go over the reason that he was there in the first place. Since the judge was asking why he couldn't afford to pay, it seems like the child support agencies, which this happens all the time, are failing. They're not doing their due diligence to get the case prepared before it even goes in front of a judge. So there's guidelines that the child support agency is supposed to follow and criteria that's supposed to be met before the case can be referred for a contempt of court ruling or hearing. Okay, so the Federal Register, and I wrote an article today about arrears, state-owed arrears in the Federal Register. There's a lot of information in there, and that was passed or issued in 2016. And still states aren't following most of what's in there. So if you got time, just go through it, and it has the table of contents. If you're looking for something specific, it'll tell you where to go and breaks down like enforcement, like what I wrote today, why they're supposed to be closing cases, different criteria that has been passed. So in this case, this is about before a case should even be referred for criminal sanctions, right? So Here's number one. States must include requirements that the 4D agency must screen the case for info regarding the non-custodial parent's ability to pay or otherwise comply with the order. The parent has to be able to comply. If they can't afford, if they're not working and you can't afford to pay, you are not violating that court order. So you shouldn't be in front of a judge anyway. Number two, the agency must screen the case for information regarding the non-custodial parent's ability to pay, which may assist the courts in making a factual determination regarding the non-custodial parent's ability to pay the purge amount or comply with the purge conditions. That's when they say the contempt of court, the civil contempt of court, you hold that parent or that person holds the key to the jail door. If you can't buy your way out, then you don't have the money, so you're not in contempt of court. So you shouldn't be there in the first place and facing a judge. Number three, the agency must provide clear notice to the non-custodial parent that the ability to pay constitutes the critical question in the civil contempt action. So these are three guidelines that the states must be following before the case even gets in front of a judge. And I can almost guarantee you that in this case, that father did not, the agency did not do the due diligence that this father was afforded before his rights were violated even further, and they threw him in jail for contempt of court. Hey, Jason. You gotta keep speaking, Marquise. Hey, Dre. Hey, Joe. I'm sorry, guys. I'm just rambling on and on. I get on here and I'm so scared of messing up. I'm still getting over my little fright of public speaking. Let me grab some water. Yes, Turner versus Rogers is case law, and they still ignore it, Joe. Hey, Isaac. Hey, Shayna. God bless you as well, and you're welcome. Thank you. Thank you for being here. Hey, if you can, hit the share button, guys. Somebody told me that a while ago. Hit share. Tell people to hit share. Benny, I'll read that in a second. Okay, so when they are, where was I? Okay, so when they established these child support orders back in the day, and they still do it, I'm sure, they used to impute income because they said a lot of default judgments because a lot of these process servers lied when they said that they served these child support complaints. And so they imputed income based on what, like if you were 22 and a 22-year-old man, and in your area a 22-year-old man was supposed to be making $40,000 a year, that's how they based the child support order, right? Well, since then, what's up, Rod Only Fam? Y'all get a chance, follow Rod Only Fam. So since then, they knew that was illegal then, and the arrears got so high because people couldn't afford what they were imputing. I mean, just because Joe Blow makes $40,000 a year or whatever doesn't mean that this person over here is going to make that money. So they knew that was wrong. I guarantee you in Texas, that's where I am, everything that I'm saying does apply. This is nationwide, Jose. This is nationwide. They just choose to ignore it. And this is why the protest that we did, that's why protesting, contacting your legislators, and making your voice heard is so important. This has been the law, or I have to say law. Now, I will say child support guidelines, but this is the Supreme Court ruled this. This is what the states are supposed to be doing. Turner versus Rogers, law of the land. So if they're violating the Supreme Court ruling, but there's no accountability. You see what I'm saying? So there's nobody to go behind them and say you aren't supposed to be doing this or you aren't supposed to be right. They choose not to, and nobody's holding them accountable. And really, the only reason why this judge, in my opinion, was reprimanded is because another man was punished. Another man was sent to jail as well. Excuse me, guys. And another thing, it was contempt of court. It wasn't child support related contempt of court. That's the only reason why he was reprimanded, because nobody in this whole family court child support realm of things, they don't care. So that's why it's up to us to make them care. That's why we fight so hard. And as far as the protest, I don't care if it's one of us out there with a sign in front of the building. You can protest by yourself. That's all I'm gonna say about that. So as far as the imputed income, the rules have changed as far as that as well. So when child support orders are established, the rules have changed when it comes to imputing income. They have to look at all earning and income and the basic needs of the non-custodial parent. And this is something they have to look at as well when a parent goes into court. Now, once the order is established, they still have to look at if you have the ability to pay before they can send you to jail. Ability to pay has always been there. They just chose to ignore it. Willfulness to not pay, that's always been in the guidelines. So as far as imputing income, specific circumstances have got to be met when they consider a child support amount. This list is kind of long, so bear with me, okay? They have to consider, I'm going to end up in jail too. Ted, I hope not. I hope that this video will let you know some different avenues and some information that will help you prevent going to jail. Okay? What do you want me to repeat, Adrian? This is I hope that the information that we share here at Child Support Hustle helps you guys and informs you guys of not only your rights but how to fight back. Okay, because this stuff, that's why I put the links in. If we posting it here, yeah, we post memes and things like that, but I also write articles. I like to put references up so that if you hear or you see something here, you can go and look it up and find out where it is written, as in by the state or by the government, so that when you talk to your caseworker and you tell them, well, I saw or I read, and they said, well, I don't know what you're talking about, you can go and copy the link and send it to them and say, it's right here. It's on your website. And that'll strengthen your case. Oh, they have to determine all earning and income and the basic I can never say this word, but the basic needs of the non-custodial parent who has a limited ability to pay. They have to consider that. And I put the link to what I'm reading from, where I got this from. It's in the description of this video. Okay? So they have to consider certain circumstances when they consider that order. I just said. Okay, so they have to consider the non-custodial parent's assets, residence, employment and earning history, job skills, educational attainment, literacy, age, health, criminal record, other employment barriers, record of seeking work, local job market, availability of employers willing to hire the non-custodial parent, prevailing earning level in the local community, other releasing background factors in the case. So there's a lot of factors. It's just not what you're supposed to be making with your age and your gender and that. So these are things that these caseworkers are supposed to be looking at and considering when executing the case. That's if you even go, this is for the custodial parents too, if you even go and file for child support. You know, we always say, if y'all can work it out, just avoid the child support system altogether. There's no reason they should get a penny of you or your children's money just to process a case at all. So if you can work it out, work it out. They did, and they did, Paul, and Attorney General Sessions. The letter was issued in 2014 and it was rescinded in 2016. But don't quote me on that. I will have to give you the exact years. It was issued under Lynch and rescinded under Sessions. That I know. I'm not sure of the years. I'll have to get back with you on that. But I have a copy of the letter. There's really important information in that letter and a lot of references that they can't rescind. It's there. But the actual letter, you can't find it online because it's been rescinded. But there's a lot of information in there. Okay, so if the agency caseworkers screen the cases, which according to federal government is basic program responsibility, fewer parents will find themselves arrested and forced to face judges like the now reprimanded Judge Conley. Okay, so yeah, you're right, Adrian. You're right. I have to think of it. I don't know the years exactly. I'm gonna have to go and look. I want to say I'll have to get back with you. Okay. So I have to do my little closing. So I want to make this video to emphasize again that states are not supposed to refer child support cases for contempt of court unless the agencies have done their due diligence and determined that the parent had the ability to pay and refused to pay, and not that they simply could not afford to pay. Yeah, it was under Obama's administration that they issued that letter. So here's a child support order and he's refusing or she's refusing to pay, but yet they have a villa in the south of France. Those are the cases that technically should be referred to child support. Not, I'm not working, I don't have any money, and now you want me in jail because I can't afford to pay $700 or $1,000 a month. Those cases are not supposed to be referred to a judge to issue an arrest warrant and all that kind of stuff. It's just not supposed to happen. But unless we force the legislators and the people in charge to make these caseworkers uphold what they're supposed to do anyway, they're going to continue to get away with it. So that's it for my video. If they get child support, any type of assistance, their license can't be suspended as a plus. So I don't understand what you mean, Isaac. I don't understand what you mean. I'll let you know with that letter. I'll put the letter in the comments after we get off of this live. And if you have any questions or comments for the Child Support Hustle or for me, you can reach us at either a DM or you can email email cshustle1@gmail.com. Our website is back up. I have blogs. I have a lot of information there. The childsupporthustle.com. Let me see. If you want to get a t-shirt or a Child Support Hustle book, I don't have any now. You can get an ebook, which you can order from Amazon, or the book that's in print, and you can order on our website. I gotta sneeze. And as always, guys, keep fighting. I know there's a lot of negativity going around, like we won't get anything done, but trust me, in the time that I've been advocating, which will be a little over, well, it'll be 8 years in November, I have seen reforms, I've seen changes, and I've seen parents get justice in their cases. I've helped with quite a few. So I did want to say, if our information here has helped you, or you've gotten some positive results on your case or anything like that, please leave us a 5-star rating, leave us a review, tell your friends and family so we can grow the numbers and get more people involved, because they cannot ignore all of us, and we have to start working together. Okay, so let me see. Absolutely right. They don't follow their own rules. Okay, so I'm signing off again. Thank you so much for tuning in and sharing if you did. Remember, they can ignore hundreds, they can ignore thousands, but they cannot ignore with millions. Let's go.